All right, friends, I've got my decarbonized hat on, so you know this is serious, and because climate work is all we do. So let's talk about a couple of things. The 10 things your lease doesn't say, but should. Now, from the owner's perspective, it's really time to update those template leases, particularly in building performance standard jurisdictions. And these top 10 things should help explain why. So let's go over that. Your lease doesn't say who has to share utility data or even how. Most leases say absolutely nothing about format, frequency, or confidentiality of data. Yes, some laws address data sharing and require it from utilities, but there is an absolute need, and it's really helpful to have some clarification in the lease. So that's number one. Number two, your lease doesn't say what happens if a tenant causes you to miss a compliance target or deadline. Owners and tenants really need to work together now more than ever in building performance standard jurisdictions. And because leases are the document that governs the owner-tenant relationship, you need to bake in that cooperation in the contract so that it's enforceable, it's clear, it's transparent, everybody's on the same page. Number three, it doesn't say whether penalties can be passed through to tenants. Again, your lease is silent on the largest potential area of exposure. Now, the law may address this, in some jurisdictions it does, but leases can help clarify key aspects like what does it mean to cooperate, provide reasonable access, and other things like that. So the law may cover it, but you also probably want to clarify it through leases. Leases are completely silent on what is the largest potential area of exposure for owners, particularly large building owners. Your lease doesn't say who pays for capital improvements that may be needed for compliance. This is where a cost recovery clause comes into play, and it's basically like use it or lose it. This is transparent cost sharing that benefits tenants in the form of lower utilities in sort of an amortized way. There are lots of different examples of cost recovery clauses. We help with them all the time, but your lease doesn't say, chances are, what happens if capital improvements are required to comply with building performance standards. Clarify that. It also doesn't say how your tenant can actually, quote unquote, use the space. These are the classic use provisions in leases, and this could significantly impact compliance. Use clauses should meaningfully address BPS requirements, meaning you may have to put some restrictions on how tenants can use their spaces, or how many big events they can have every year, or what they're doing with evening lights on and things like that. Tenant use of the space, particularly if it switches over, we'll talk about that in a minute, is really important, and use clauses often just get overlooked as standard. They should absolutely be updated in BPS jurisdictions so that owners know how tenants are using that space. It doesn't say what happens if your tenant subleases related to the first part, or the last example I just gave. Does the subtenant even know about BPS requirements? Yikes, they probably don't. And so making sure that BPS requirements, use restrictions, other things are clear in the sublease and pass through to those subtenants, everyone's on the same page. As an owner, you don't want to lose control of potential compliance issues just because the space is subleased. So make that clear in the lease. Your lease likely doesn't provide access to fix a compliant issue. Owners are responsible for performance issues and requires really a higher level of access to inspect and resolve issues really quickly. So access to individual tenant spaces with some reasonable restrictions are key to making sure that buildings stay in compliance. If there's an issue, it's resolved quickly before the building gets out of compliance and out of control. Doesn't require your tenant to tell you before they tank your score. Kind of like this one. Owners need notice and more information before big changes. If all of a sudden the use of a space is going to change, owners really also need to keep control of tenant improvements. Leases need to be updated so that there's good communication between tenants and owners if something changes with respect to the space that may impact compliance. The last thing, it doesn't bake in cooperation. It's just not how leases are traditionally designed, but here's the catch. Building performance standards are completely new regulatory tools, and they require owners and tenants to work together. If you've seen any other of my videos, you know why that's the case. Performance really requires collaboration, and the lease should also require it. There's ways to do that contractually, kind of little mini mediation clauses, or not just opportunities, but requirements to try to resolve issues quickly and fairly. Leases need to be updated for that. So bottom line, you need to update your lease. It likely doesn't even contemplate this brand new legal regulatory requirement. We do this all the time. We can help. If you have questions, reach out. Top 10. There we go.